All right, I apologize for the lateness. They have a little bill that they're talking about, it's drawing a little interest over in the Senate, so I had to go fish for a couple senators. I'm not sure what I caught. But Senator Gooch, please start us off. Senate Bill 154, I believe.
Yes, sir. Thank you, Mr. Chairman and committee. This bill was brought to my attention by the Coroners Association. They're asking that they add language to their duties for their Georgia Coroners Training Council. And the duties that would be added is, as you see, on lines 23 and 24, it's just one sentence. It would review complaints from outside parties and make recommendations concerning the retention, suspension, or removal of a coroner from his or her position. It does not allow them to remove the coroner, obviously. That's the role of the governor. So this is just to allow them to make recommendations pertaining to training and other issues that come up with their group. And this has been requested by their people.
All right, I think this come out of Chairman Jay Powell's subcommittee. Was anybody there? I was there. And what's the report of the subcommittee? Do pass. Any questions of Senator Gooch on Senate Bill 154? Number 24, Gullett.
Yes. You know, that's funny. A lot of people don't know that the coroner has the powers to arrest the sheriff. I would imagine the deputy coroner would be immediately installed as coroner if the coroner was removed, so he would assume those responsibilities.
Representative Gullett.
Thank you. Quick question: how is it done today? So, if there's a complaint against the coroner, doesn't it go to the
If the coroner,
Attorney General's office, and then
there's a combination. If I didn't mean to cut you off, but I've experienced that in my prior job as county commissioner. If an elected official, per se, let's say it's a sheriff or a coroner or commissioner, is charged with a crime or is charged with wrongdoing, the governor can impanel a group of other peers, along with the Attorney General, maybe a fellow commissioner, or in this case, maybe a fellow coroner, and another outside party. They would review the facts of the case, and then that group, along with the Attorney General, would recommend to the governor what they thought, whether or not that person should stay in office and serve out the rest of their time, or if a suspension or removal would be necessary at the time. This doesn't change that. This bill only allows the training council to make a recommendation to the governor or to other bodies. It may be the fact that they don't have all their training in. Some of the issues that they're having right now in some of the counties pertain to the training requirements aren't being met. And so this council wants to make sure all the coroners are doing their job properly. Part of that training requirement is important to them, so they want to sort of police themselves before they get in trouble and then go before the governor or such of a panel. They don't want it to get that far.
Representative Shannon.
Thank you, Mr. Chair. You asked about the report yesterday from subcommittee. I voted no. I had a question about how many were elected versus appointed, and just that, you know, if they're elected, the folks who elected them could handle if they don't feel like they're doing a good job. So just stating the same objection.
Sure. And the medical examiners are typically...
All right, any other questions from members of the committee?
Thank you.
Y'all the ones got to get back, right?
Yeah, we need to go back.
All right, thank you. At this time, I'll entertain a motion. Got a motion to pass there. Second. Further discussion. Hold on. All those in favor, please signify by saying aye. Aye. Anybody else? All opposed, same sign. No. All right. And who's going to carry it in the House?
I can't remember the representative's name. He came up to me a day or
Really?
There he is. There he is.
Have you read the book, Winning Friends and Influencing
Listen,
House Members?
You know, I just want to be as smart as a state rep when I grow up, but I'm not there yet.
You're awful young.
Thank you. I appreciate it.
Thank you.
All right.
And you'll bring the other one over.
I will.
You remember the name, or we need to just write it down?
That would be Wilkinson and
There you go.
Mullis. Talk to him.
Yeah, I think we're going to present Mullis here shortly, but Wilkinson, thank you. Senator Stone. He's bringing us Senate Bill 130.
Local legislation, this is,
It's not a local legislation.
I'm sorry.
This is a
Johnson
general bill in the
County.
House. We talked about that on the way over here, the differences
Right.
between the two.
It's a Johnson County bill to make their probate judge a nonpartisan election. We have the unanimous resolution from the county commission. Judge Mary Jo Buxton sent it over.
Thank you. Any questions regarding Senate Bill 130 for Senator Stone? Number 2.
I'd like to be recognized to make a motion.
What is the motion?
I move that this House moves Senate Bill 130 forward with a due pass recommendation.
And that comes from the subcommittee chair.
It does.
It does. We got a motion on the floor that I recognized. Do I hear a second? Got a second. Any further discussion? All those in favor signify by saying aye. Aye. Those opposed, like sign. No. Thank you. Now, who's going?
I believe Matt Hatchett, your Chairman Hatchett, we both represent.
You trust him with that? All right.
Yeah.
Thank you.
Thank you.
Senator Brass, you bring us 177, Senate Bill 177.
Yes, sir. Thank you, Mr. Chairman. It's a simple bill dealing with local redistricting. If they're going to draw maps using third parties, we're just simply asking them, or actually telling them to send them to us first before they vote them out of their local municipalities. We're not changing the amount of work. We're just simply changing the order. GMA and ACCG have both signed off on this. It's bipartisan. The minority leader in the Senate was my second signer.
Right, and I think for the members in the sub, and I'm going to ask Chairman Powell about this, I think Ms. Gina from Legislative Reapportionment had comments about this. Chairman Powell?
It's not a sub on this.
There's a sub. I'm not aware of it, Mr. Chairman.
Right, I think it's, no, I just was, for the members that weren't there, and I don't know, but I'm assuming our reapportionment office weighed in and talked about why this was needed. If you'll just give us a little bit about that.
Chairman. Subcommittee heard this bill. Makes a lot of sense, unusual for a Senate bill. But this, over the history of this, my 4 or 5 reapportionment sessions, it made a lot of sense. Because when local governments are doing their reapportionment, a lot of them have hired and bought special packaging for redistricting and all, and then they come up with their own, they vote on it. By the time you get it up here to the legislature, a lot of times it's flawed. It's not in sync with the true figures of what we do by code action. And the only thing this bill says is that if they're going to use their own, they got to get it up here in time, but they prefer to recommend that local governments use the legislative reapportionment office. That's what the bill does. It's a straightforward, good bill. And as the subcommittee chair, I recommend that this full committee pass this bill.
All right, I'm going to hold you off on that recommendation real quick. We have a question from Representative Oliver.
Sub or not?
No.
As this committee is aware, the particular programming that Legislative Reapportionment Office is contrary to the precinct programming in the counties. This has caused an enormous amount of problems in the DeKalb County cityhood annexation issues because we are not allowed to draw a district based on our existing city limit lines in DeKalb based on reapportionment office. You can only use my computer. And that is been a substantive change based on a procedural technology. And I don't know what program Legislative Council is going to use in the next reapportionment. I have no idea. But I'm concerned about this discrepancy that's causing problems, at least in my district.
Well, I think you referenced annexation. This bill doesn't deal with annexation at all. It's simply on district lines, whether it be a Board of Education, county commission districts, city districts. That's simply all we're dealing with, not annexation, because in annexation, you still got the, what meets and bounds or whatever it is.
It's the same principle, though.
Right.
Our local districts are drawn based on creeks and rivers, not necessarily census tract districts. So what you're saying is you're permanently putting into law here that
Well,
If I'm
the-
reading it correctly, and I might not be, that DeKalb County cannot draw its own district based on its own.
No, ma'am, that's not what we're saying at all. In reference to that, I think the last city to use it was 2008 in Dunwoody, when Dunwoody was created. But again, we're simply dealing with district drawing. We're not telling them they can't use a third party. We're not telling them they can't, I mean, they can draw it with their hand if they want. But, you know, as you know, we have to put it into code. And what we're finding is coming up to us, and when we're putting it into code, it's not meeting federal guideline, federal or state laws, or it's going against the Voting Rights Act in 1965. And so then we're having to send it back to the local municipality, and then they've got to redraw it, and then they have to wait till their next scheduled meeting, and they're not able to vote it out in time to get back to us. And so in some cases, we've had maps had to wait 2 years to be redrawn before we could get back to it. So this is simply, again, it's not changing what is done, it's not changing the process, it's just simply changing the order. They just simply, if they're gonna do it themselves, which we're still allowing, they just simply have to send it to us first, and then they vote it locally. Does that make sense, Representative? Or did I answer your question? I guess would be a better way to phrase that.
All right, any further questions? At this time, I'll entertain the motion.
Chairman, the committee, as a chairman of the election subcommittee, I recommend that we forward Senate Bill 177 forward with a due pass recommendation.
Got a due pass recommendation. Do I hear a second? It's got a second. Any further discussion? All those in favor, please signify by saying aye. Those opposed, like sign. Ayes clearly have it. Thank you. And I'm going to let, before you go into, who's going to represent this bill for you?
The distinguished Representative Rick Williams.
I'm sorry, who? You say Representative Rick Williams?
Yes, sir.
I didn't hear that first part. I didn't know that was his first name.
I tried, brother.
You did prove a point. You'll say anything to get a bill passed. All right, sit tight real quick. We're going to let, because me and you're going to cover another subject matter here real quick, but we're going to move on to Senate Bill 77? No. 171, Senator Wilkinson.
Thank you, Mr. Chairman. Members of the committee, Senate Bill 171 provides for a 5% increase in the minimum pay for the constitutional officers in each county. That would be the sheriff, the clerk of court, the tax commissioner, and the probate court judge. This minimum salary has not been increased since 2006. Now, there have been some, we got in a discussion yesterday, cost of living adjustments and merit-based pay raises that have gone into effect since that time. I would point out there was one time during that time period when there were 7 years, there was no increase at all. When you look at the salaries and you look at the very important responsibilities that these officers have in each county, we feel like this is a well-deserved increase in their minimum pay. There was some concern expressed in the Senate about some of the larger counties, Fulton, Cobb, Gwinnett, and DeKalb, who have their own local statute, and they are paid much more than the state minimum. This would not be an increase for the officials in those counties. So with that said, I'll be glad to entertain questions, and I'd urge your approval of this bill.
Thank you, Senator Wilkinson. I think this passed the Senate 50-1 or something like that. This time, the chair will entertain any questions for the senator. Chairman Powell.
My good friend and fellow delegation member of Northeast Georgia, did I understand you say a 5% increase on the base?
On the minimum salary.
I'm looking at it, looks to me to be a 10%.
What the reason it looks that way on the bill, I mentioned there had been some cost of living increases and some adjustments in the past 13 years. So when we listed those figures, we listed the current minimum at the present time, because that minimum has been raised with those increases since that time.
Any further questions? This time the chair will entertain a motion. Got a motion to pass, do I hear a second? Any further discussion? All right, great. All in favor of, what's that number again? 171, Senate Bill 171, signify by saying aye. Those opposed, like sign. Ayes have it, thank you.
Thank you, Mr. Chairman.
Who's going to carry it for you?
Chairman David Knight.
Chairman David Knight. Got it. Thank you. The distinguished Representative Perkle. Rick, see how that sounds different coming from a House member than it does a senator? Came from a House member.
I'm going to change my name for that. Thank you, Mr. Chairman.
He brings before us House Bill 571 first.
Okay. Thank you, Mr. Chairman. House Bill 571, LC 470093, simple bill that makes for the nonpartisan nature of the Chief Judge of the Magistrate Court of Ben Hill County. It came as a unanimous recommendation from the County Commissioners of Ben Hill County.
Any questions for Representative Perkle? House Bill 571. Chairman Powell.
Be recognized for a motion that we move SB 571 forward with a due pass recommendation.
You're recognized for that purpose.
I just made it.
Although, do we have a second? A second. All those in favor, please signify by saying aye. Those opposed, like sign. No. And we got a no to Ben Hill County. But it does carry, and you're, of course, going to do the work. 571. Let's move on to 572.
Thank you, Mr. Chairman. LC 470092 is HB 572, similar for Ben Hill County. This is for the probate judge to make this a nonpartisan position.
All right. Any questions for Representative Perkle? Recognize Chairman Powell.
Mr. Chairman, your subcommittee has heard House Bill 572, and I recommended it back for the full committee with a due pass recommendation that came out of the subcommittee unanimous.
All right, we got a motion on the table. Do we have a second? Further discussion? All those in favor, please signify by saying aye. Those opposed, like sign. No. I don't know. Ayes clearly have it. Thank you, Representative Perkle.
Thank you, sir.
Members, stick close. We're going to stand in adjournment for a few moments. All right, we're back. Recess. And we're going to hear Senate Bill 77 by Senator Matt Brass.
I'm actually standing instead of Chairman Mullis, but this bill is very simple. Simply protects all monuments. Be more than happy to take questions. It's even simpler than my last bill.
Let's see if you get a few more questions than coroners or whoever. Trammell, Representative Trammell.
Thank you, Mr. Chairman. To the gentleman, aren't monuments already protected under the law? I thought state law preempted the ability of a local government to do anything, and I'm kind of struggling for what this bill adds to it other than some penalties, which I would like to ask about. But my first question is, aren't they already protected under existing law?
It's my understanding some are. We're making sure all of them are.
Is it not true that we added civil rights monuments? And help me, Mr. Leader. I think we did add some new things to protect, did we not?
That's the question I'm asking.
I think the
Are they
answer is
already-
yes. So we were looking at to make sure that it was universal to help all.
It's my understanding there was some ambiguity there with some of the civil rights monuments, so we wanted to make sure they were covered.
Mr. Chairman, if I might ask another question
Yes.
about a different section. So as I read this, I want to make sure I understand what the effect of lines 48 through 61 are. That if somebody goes and they damage, let's say they damage a civil rights marker or monument in some way, and it costs $5,000, this provision says they'll be liable for triple that amount of the cost of repair and subject to punitive damages. Is that right?
That is correct.
Okay, one additional question, Mr. Chairman, if I might.
Yes.
To whom are they liable?
I guess they'd be liable to the state, Mr. Leader.
So, Mr. Chairman, I'm not sure I'm clear on that. I understand the gentleman's answer, but I just want to make sure that this is what you're saying. You're saying the state of Georgia would reap a financial windfall from damage to monuments that may not be on state property if they're located on a county government property or a city property, that it would be the state that would have the ability to collect the treble damages and punitive damages?
Well, Representative, I think the intent there is number one to.
And the fairness to the senator, that's a great legal question, and you know he's presenting on someone else.
Fair point.
To avoid gotchas, we're going to let somebody with a legal mind at least equal to yours.
Fair point, Mr. Chairman, but I think that is an open question in the bill.
Sure, I understand. Chairman Fleming.
Thank you, Mr. Chairman. It is not an open question in the bill. If you look on line 58, it says, should a public entity or owner of the monument? Right there is where it tells who the
What line
money
is
goes
that?
to. Line 58. That refers to who is bringing the action. Should a public entity or owner of the monument, and later on down there it says prevailing in the action. So that is the person who the damages would be paid to. If it's a county, it goes to a county. If it's a city, it goes to a city. If it happens to be the state, it goes to the state.
Thank you for that clarification, Chairman of Judiciary Fleming. Representative Collins.
One of the things I asked the author of the bill, Senator Mullis, yesterday in subcommittee was the fact that for decades now, and I think my colleague Representative Williams would agree with me over here, we go into cemeteries quite often, and monuments and markers and statues and those kind of things in cemeteries are torn down and been vandalized. This puts some teeth into legislation that allow those folks in the local government or maybe a private individual to go after people for monetary damages. Is that correct?
The gentleman knows of which he speaks.
Thank you, Representative Collins. Representative Wynn.
Thank you, Mr. Chair. Chairman, could you explain, we talked about this a little bit yesterday in sub, what is the reason for lines 83 and 84 that does not allow a monument to be relocated to a museum, cemetery, or mausoleum?
Are you talking to me?
Yes. Thank you, Senator.
I forgot I was a chairman. You know, I don't know the intent there. You know, again, this isn't my bill, so I can't speak to the intent. But you know, it simply just says you can't relocate.
We're going to let Chairman Fleming have a bite of that apple.
Thank you, Mr. Chairman. I was at the subcommittee yesterday when you asked that question then, and the answer, as I recall.
I'm sorry. So did you get an answer from the author of the bill to that question yesterday, Representative Wynn?
I did get an answer, but I still am not, I'm a little unclear.
But you would agree that the author should be clearer than the person presenting it on his behalf?
I'll agree with that.
Representative Fleming, Chairman Fleming.
So the response was the purpose of lines 78 through 84 is to allow a local government, or in this case, or a case a state, to move a monument when needed for things. And the example given yesterday was like road expansion. The purpose of the language on line 83 and 84 is because the intent is to allow them to move it to fix something, not to move it to put it in a place where it can't be seen as prominent as it was when it began.
Mr. Chair, if I may.
Yes. Is this going to be a question you didn't ask? Yes. I just don't want
Yes,
to put him I wouldn't want to put anybody in that kind of disadvantage.
Sure, this is a question, and perhaps Chairman Fleming can help me understand this as well. So would it prevent something, for example, in our state capitol, the first and fourth floors are actually considered museums, and we preserve, for instance, flags there, which is considered a monument. So would this bill prevent us from collecting more items for the museum on the first and fourth floor of our capitol?
It would not.
Thank you.
Thank you, Representative Wynn. Representative Shannon.
Thank you, Mr. Chair. I do have a similar question from yesterday, which is, what are some of these cities are so small? For example, City of Decatur, which is located partially in my district. Lines 80 through 82 talks about if you want to move the monument because you're doing construction, or you have a reason that it needs to be moved. The language is very strong. It says it needs to be moved to a site of similar prominence, honor, visibility, access within the same county or municipality. I mean, some of these cities don't have places where you can say it's just as prominent, just as visible. So, well, what are they supposed to do? I mean, some of these cities are so small. And Representative Fleming offered a suggestion yesterday. I did a quick Twitter poll, very scientific, asking.
Oh, that's good. Very Twitter poll, very scientific.
Very scientific, asking how many people knew where the Capitol building was versus Liberty Plaza in the case that you'd have to move one of the statues around the Capitol. How would cities be able to comply?
Well, Representative Shannon, I represent a little town called Harrelson, another one called Turin. Decatur is not small. There's plenty of room to move to a similar spot in Decatur, and those towns that are much smaller than Decatur, they've got room as well. So I represent some of the smallest cities and towns in this entire state, and if they can do it, I'm pretty sure Decatur can do it.
No, Decatur could not.
Okay.
All right, Representative Oliver.
Can you give me a policy reason as to why the state of Georgia should tell DeKalb County and City of Decatur what to do with the monument on its county square? What's the policy behind that?
You'd have to talk to the author on that.
Was that question brought up yesterday, do we know?
I had an amendment yesterday, Senator Brass, that would return local control to cities and counties to make their local decisions on behalf of monuments. Would you object to that amendment if I were to offer it again?
Well, as
I
you know,
would.
as
I'm
you
not the
know,
author of the bill, so I would have to object to it.
Senator Oliver, as you know, I'm sorry. It actually sounds nice sometimes.
You just got demoted.
Representative Oliver, as you know, I prefer to have any amendments 2 hours in advance. And I think that was an amendment that was offered yesterday, was it not?
It was.
Thank you.
So it's been offered more than 24 hours.
But you get the chairman's point. You've seen this movie before, but thank you.
I've seen this
Represent-
movie before, but I think there really is a serious policy consideration that is totally inconsistent with any respect for local control, that the state of Georgia tells the city of Decatur what to do with its opolis on Confederate Monument Day.
Representative Rick Williams.
Thank you, Mr. Chairman. To my colleague, Jay Collins, any desecration, theft, or vandalism in a cemetery is already a felony in the state of Georgia. But a lot of these monuments are still owned by organizations. I know the UDC, just because they might construct a monument and put it in somewhere, they retain ownership of it, and this is just giving protection to what's still private property but is publicly displayed. But I'm in favor of your bill. I've actually had to repair vandalism to some monuments and things, and yeah, it's a good bill. Thank you.
Leader Trammell.
Thank you, Mr. Chairman. I just want to follow up. I think this is probably for Representative Fleming. But in on this question of who, the liability and to whom it is, I see your language that you cited at lines 58 about the public entity owner of the monument. But as I read this, the second part of that provision would open it up to literally any Georgian person, group, or other legal entity prevail in any action under this code section. And I just wanted to see if that was your reading, that any person or organization would have standing under this to pursue liability of the treble damages for any monument damaged anywhere in Georgia.
Chairman Fleming.
You have to own something before you can sue somebody for damaging it. If someone breaks into your car, I can't sue that person on your behalf unless you give me that authority.
So Mr. Chairman, if I might,
Please.
would the committee be open? I agree with the gentleman about the premise of standing, and I think that we have to be very careful when we open up the standing of individuals or groups to sue. And I would ask if the committee would be friendly to a strike amendment to eliminate the wordings "or person, group, or other legal entity."
I would not.
And Mr. Chairman, the question that I would have is what the hostility to that amendment would be and what the purpose of that language is.
For clarity, on what line would you want to strike such language?
Line 58.
Well, mine would be a policy, as you would know, as you and I have talked before, and you were kind enough to let me know about not bringing other amendments in other situations because of the 2-hour rule, then I would expect that you would want me to be consistent as well.
At this point, Mr. Chairman, I'm just exploring, as I understand Representative Fleming's point, the amendment would be tendered in a friendly manner. If the desire is to protect the public entity owners of monuments, then what we would be doing by placing that language is we would be restoring to the public entity owner the sole ability and recourse under the provision to collect the treble damages. Otherwise, as I read this, it's a race to the courthouse, and anybody who gets there and gets a judgment obtains the treble damages and the ability to pursue exemplary damages under the statute.
If I may, Mr. Chairman, that is absolutely incorrect, and it's because of what you and I spoke about earlier with standing that you acknowledged was the law and how one could bring an action. I cannot sue someone who damages your car, only you can do that, and I'll give you an example of why the language in the bill is accurate. In my small town of Harlem, Georgia, for example, we have a cemetery, a very large one. The city itself does not own that cemetery. That cemetery is owned by what will be on the line, end of line 58, something referred to as a legal entity. There is a group of citizens that sustain that cemetery and keep it up and manage it. So you've got to have the ability for people other than a public entity to bring an action against someone who destroys the monuments as they're described in this bill, and that language in all of 58 that you would want to strike would take away the example that I just gave you.
Well, Mr. Chairman, this is at the end of the day a lawyer's argument about standing, but as the gentleman knows, statutes can confer standing, and that's the fear that I have with the language that we're talking about.
Once again, we do want to confer standing to the entity that I talked about in my hometown that owns that cemetery, because it is not my local government. It is a private group that has maintained that cemetery for decades, and if somebody goes into that cemetery and destroys something there, such as a monument or any other example of something that is described in this bill, you want whoever owns that property to have the ability to go after the people that destroyed the monument, because the city of Harlem could not. They don't own that property, nor are they managed with caring for it. So somebody's got to go after them
All
when
right.
they do the damage.
As much as I'm pretty sure I'm not the only non-lawyer that enjoys the ping pong between lawyers, at this time I'm going to entertain a motion. Got a motion to pass. Got a second. Any further discussion? All those in favor, please signify by saying aye.
Aye.
Those opposed, like signs. No. Ayes clearly have it. We're adjourned.
Thank you, Mr. Chair.
Oh, Mr. Brass, do you know who's going to be presenting this? I can get it later. I can get it later.